Hello everyone, and welcome to the July 2025 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case we will discuss is the recent applicable unpublished opinion per curiam of the Court of Appeals that was issued on July 23, 2025, of John Davis as next friend of FD, HD, and ID minors versus Auto Club Insurance Association and Citizens Insurance Company of the Midwest. The second case law update actually focuses on two cases in which the outcome of both has led to one written opinion by the Michigan Supreme Court on July 3, 2025. The first case is C-Spine Orthopedics PLLC versus Progressive Michigan Insurance Company. The second case is Perry Wallace and Affiliated Diagnostic of Oakland and One Step Rehab LLC versus Suburban Mobility Authority for Regional Transportation and Janet Scotza. Lastly, we will focus our discussion on the trending topic in PIP litigation of fraud and the filing of Candor motions. I will first give you a brief overview of the topic and the Candor case. Second, we will discuss the case of Ronald, Whigham, and Citizens Pharmacy, ZMC Pharmacy LLC, and Pioneer Lab Houston LP versus Farm Bureau Mutual Insurance Company of Michigan and James Williams Jr., which is an unpublished opinion per curiam of the Court of Appeals that was issued on June 23, 2025. The first case we are going to discuss is the unpublished opinion per curiam of the Court of Appeals that was issued on July 23, 2025, of John Davis as next friend of FD, HD, and ID minors versus Auto Club Insurance Association and Citizens Insurance Company of the Midwest. This case discusses the issue of injured minor claimants' domicile on the date of loss and its effect on their claims for PIP benefits. The subject accident occurred on January 30, 2021 and involved three minor children who occupied a vehicle owned and operated by their aunt and insured by Defendant Auto Club. The parents of the minor children still had legal custody of the children on the date of loss. The parents lived in an extended stay motel from approximately April 2020 to March 2021, so at the time of the accident. The minor children stayed with their parents in the extended stay motel until November 2020, at which time they began staying at their aunt's house during the week only, while their mother was on pregnancy bed rest. The minor children stayed at the hotel on weekends with their parents. At their aunt's house, the minor children had their own beds in shared bedrooms with their cousins and kept their personal belongings and clothing there. The parents never stayed the night at the aunt's house with the children. This living arrangement was in place until January 2021, the subject accident. The parents did not own a vehicle on the date of loss, and there were no resident relatives in the hotel. A claim was made on behalf of the minor children under their aunt's policy with Auto Club. Under MCL 500.3114 subsection 1, the minor children in this case could only claim entitlement to benefits through their aunt's policy if they were, quote, domiciled in the same household, unquote, as their aunt on the date of loss. Auto Club denied the claim on the basis that the minor children were not domiciled with their aunt on the date of loss. A claim was then made to the MAIPF under the MACP, which was later assigned to Citizens Insurance Company of the Midwest. The father then commenced this PIP action against both Auto Club and Citizens. Defendant Auto Club moved for summary disposition under MCR 2.116 subsection C10, arguing no genuine issue of material fact that the minor children were domiciled with their parents on the date of loss and were therefore not entitled to PIP benefits through their aunt's policy. The trial court denied Auto Club's motion and ruled that the minor children were staying with their aunt indefinitely because there was no stable, suitable housing available for the children. Because of this, the trial court found that on the date of loss, they were domiciled with their aunt. Auto Club was ruled by the trial court to also be the highest priority insurer. Auto Club filed a motion for reconsideration, which was denied, and this appeal followed. The Court of Appeals ultimately ended up agreeing with Auto Club in that the minor children were domiciled with their parents as a matter of law, and thus they were found not to be entitled to PIP benefits under their aunt's Auto Club policy. The court cited the Michigan Supreme Court case of Grange Insurance Company of Michigan versus Lawrence in saying that it is well established that a child, regardless of his parents' marital status or his multiple legal residences, may also have only one domicile at any given point in time. The facts of the matter reflected that on the date of loss, the minor children's parents were married and had legal custody of the children. As such, they were considered domiciled with their parents as a matter of law per the court. The court also found that the factors that the parties relied on in the summary disposition motion briefing contained in the cases of Workman versus Detroit Automobile Insurance Exchange and Dairyland Insurance Company versus Auto Owners Insurance Company were irrelevant to the determination of the minor's domicile. The court ultimately reversed the trial court's decision and remanded for further proceedings. As I previously indicated, the second case law update I have for you focuses on two cases in which the outcome of both has led to one written opinion by the Michigan Supreme Court. The first case is C-Spine Orthopedics PLLC versus Progressive Michigan Insurance Company. The second case is Perry Wallace and Affiliated Diagnostic of Oakland and One Step Rehab LLC versus Suburban Mobility Authority for Regional Transportation and Janet Zotka. This combined Michigan Supreme Court opinion was issued on July 3, 2025, and discusses whether a party who assigned their claims for PIP benefits to a third party may still sue to resolve those benefits. Here, plaintiff C-Spine Orthopedics PLC filed two lawsuits against Progressive Michigan Insurance Company to recover PIP benefits for treatments provided to a couple who were injured in a car accident on May 23, 2018. The couple assigned their rights to seek PIP benefits to C-Spine upon treatment. As to the other case, plaintiff Perry Wallace filed a lawsuit against Suburban Mobility Authority for Regional Transportation, seeking PIP benefits for injuries sustained in a smart bus accident on October 2, 2019. Wallace assigned her rights to PIP benefits to her medical providers as well. C-Spine entered into agreements with several factoring companies, assigning its accounts receivable, including claims for unpaid PIP benefits, to these companies. Progressive argued that C-Spine lacked standing as it had assigned its rights. C-Spine countered with counter-assignments from the factoring companies, claiming restored rights to sue. The trial court initially denied Progressive's motion, but later granted it, concluding C-Spine lacked standing. The Court of Appeals reversed this decision, and the Michigan Supreme Court further ordered oral arguments on Progressive's applications for leave to appeal. Wallace further obtained mutual rescissions of her assignments from her providers after Smart moved for summary disposition, arguing Wallace was not the real party in interest. The trial court denied Smart's motion, but the Court of Appeals reversed, citing the one-year back rule of MCL 500.3145 as bar to recovery. The Michigan Supreme Court ordered oral arguments on Wallace's application for leave to appeal. Ultimately, the Michigan Supreme Court held that both C-Spine and Wallace had standing to file their respective lawsuits, but they were not the real parties in interest at the time of the filing because they had assigned their claims for PIP benefits to third parties. The Supreme Court further held that defects in real party and interest status can be cured after filing a lawsuit, and the one-year back rule does not affect whether a plaintiff is a real party in interest, though it may bar recovery. There are several key takeaway holdings to note from this outcome. First, assignments are absolute transfers of rights, extinguishing the assigner's rights. However, parties to an assignment may execute counter-assignments, which will restore a party's interest in the assigned claim. A party's real party and interest status may be remedied after the complaint is filed. The Michigan Supreme Court held that C-Spine had standing to file its lawsuit, but was not the real party in interest at the time of the filing because it had assigned its claim to factoring companies. However, C-Spine's real party and interest status was restored through the counter-assignments. This case was remanded to the trial court for further proceedings to address whether C-Spine can cure the real party and interest defect by amending its complaints to reflect the counter-assignments. The court also noted that the one-year back rule does not affect whether a plaintiff is a real party in interest, though it may bar recovery. Second, Any party who attempts to cure their status as a real party in interest after filing a complaint must take, quote, some action in the litigation, unquote, to permit the court to evaluate the effectiveness of the change in parties and their respective status, such as filing an amended complaint. Rescission is an equitable remedy that does not automatically operate by law and requires court discretion. It can potentially restore the assigner's status as the real party in interest if recognized by the court. The Michigan Supreme Court held that the real party in interest status may be remedied if not present at the time of the initial filing of the complaint by taking various steps within the litigation to bring in the proper parties. These efforts may include filing an amended complaint, joining or substituting the proper party, or via intervention. Similarly, an assignment which has been revoked or counter-assigned back to the plaintiff should be identified in an amended complaint. Lastly, rescission is an equitable remedy that does not automatically operate by law and requires court discretion. It can potentially restore the assigner's status as the real party in interest if recognized by the court. The Michigan Supreme Court held that Wallace was not the real party in interest after assigning her claims to medical providers. However, the court reversed the Court of Appeals decision and held that Wallace could reobtain her status as a real party in interest after obtaining mutual rescissions. The Supreme Court vacated the Court of Appeals holding that Wallace's claims would be barred by the one-year back rule if the assignments were revoked. The case was remanded to the trial court to consider whether equitable rescission should apply and whether the real party in interest defect could be cured via such equitable rescission. Justice Welch concurred with the majority opinion, but wrote separately to note her, quote, continued belief that several of the court's recent no-fault decisions are inconsistent with the Anduri ruling, unquote. Justice Zara wrote a dissenting opinion despite agreeing with two of the majority holdings, but he disagreed with its holding regarding defects in the real party in interest being curable after the filing of the lawsuit. Thus, he would have affirmed the Court of Appeals in the Wallace decision and reversed it in C-spine. Finally, I wanted to discuss the trending topic in PIP litigation of fraud and the filing of Candor motions. First, by way of background, in Candor versus Farm Bureau Mutual Insurance Company of Michigan, the Court of Appeals made clear that a person commits a fraudulent insurance act under MCL 500.3173A subsection 4 when he or she 1. Presents or causes to be presented an oral argument or written statement, 2. Which is part of or in support of a claim for no-fault benefits, 3. Where the claim for benefits was submitted to the MAIPF, 4. The person must have known that the statement contained false information, and 5. The statement concerned a fact or thing material to the claim. The result of the binding Candor decision is that it essentially put assigned claims on equal footing with regular personal no-fault policies with respect to fraudulent statements and actions. Previously, the defenses available to combat fraud and assigned claims were ambiguous because the case of Bari versus IDS Property Casualty Insurance Company did not apply to assigned claims, and the questions remained about the interpretation of MCL 500.3173A. Now, assigned insurers in litigation have the opportunity to defend against fraud, just as they would if someone were to have a personal policy of insurance with them. These Candor motions have begun to steadily increase since the case came down, with some judges becoming receptive to granting same on a case-by-case basis. With that, I wanted to bring up the unpublished Court of Appeals case of Ronald Whigham and Citizens Pharmacy, ZMC Pharmacy LLC, and Pioneer Lab Houston LP versus Farm Bureau Mutual Insurance Company of Michigan and James Williams Jr. This case represents the latest Candor analysis performed by the Court of Appeals. This case discusses false and material misrepresentations per MCL 500.3173A subsection 4, specifically relating to household replacement services claims. On August 5, 2021, plaintiff was operating a motorized scooter when he was struck by a motor vehicle owned and operated by defendant James Williams Jr. On the date of loss, plaintiff did not own a motor vehicle, did not maintain a no-fault insurance policy, and there were no applicable no-fault policies in his household. Therefore, plaintiff applied with the MAIPF for PIP benefits under the MACP. His claim was assigned to Farm Bureau. In addition to a bodily injury negligence suit, plaintiff filed suit against Farm Bureau, claiming entitlement to PIP benefits, which included both medical benefits and household replacement services. Specifically, plaintiff claimed reimbursement for household replacement services provided from August 1st, 2021 to December 31st, 2021. Note that the August 1st date is 4 days before the subject accident. Plaintiff submitted household replacement service statements each month asserting that his household replacement services provider performed various tasks for him around the home. Each of these statements were purportedly signed by plaintiff and his provider. The statements further reflected that his provider performed services while plaintiff was hospitalized for several days on 2 different occasions. One statement also claimed that plaintiff's provider took out the trash 15 times that month. However, plaintiff's medical records reflect that he fell in November 2021 while he was taking out the trash himself. Throughout discovery in this matter, it was revealed during plaintiff's deposition that his provider began providing services on the accident date. Plaintiff later testified that he was hospitalized for a few days following the accident and that his provider did not help him until several days after that. In sum, plaintiff admitted that this statement was incorrect regarding the date his provider began helping him. Plaintiff's provider testified at his deposition that he had been providing home health care through the Michigan Department of Health and Human Services for approximately 10 years. Specifically, the provider had been providing daily services to plaintiff's wife before the accident. Both plaintiff and the provider admitted at their depositions that the provider was performing the same daily services for his wife before the accident as he did after the accident, including cleaning and grocery shopping. Although plaintiff claimed on the household services statements that his provider did things like washing windows, plaintiff and the provider later admitted that was untrue. Plaintiff also testified that his provider took out the trash almost every day. He initially admitted that he suffered a rib injury when he fell in November of 2021 while taking out the trash himself. He later claimed he could not recall how he injured his rib. After discovery, defendant moved for a partial summary disposition under MCR 2.116 subsection C10 with respect to the household replacement services claim. Defendant's argument was that plaintiff was not entitled to household replacement services benefits because his provider was already providing services to plaintiff's wife before the accident and the services did not change after the accident. Defendant further asserted that plaintiff claimed payment for services that the provider testified that he never performed and for dates that he was hospitalized. In response to this motion, plaintiff argued that there was no evidence that he knowingly made a false statement. The trial court granted defendant's motion and dismissed plaintiff's claims for household replacement services, among other claims, with prejudice. At the trial court's request, defendant moved from summary disposition on the remaining claims, asserting that plaintiff's false statements regarding his household replacement services claim warranted dismissal under MCL 500.3173A subsection 4. In response, plaintiff argued that defendant had not established that he made willful misrepresentations. The trial court denied the motion and defendant moved for reconsideration under MCR 2.119 subsection F, arguing that the trial court palpably erred by denying its motion, given that the trial court previously held as a matter of law that plaintiff made material misrepresentations regarding his household replacement services claim. The trial court granted the motion for reconsideration and granted summary disposition in favor of defendant. The trial court then dismissed with prejudice all of plaintiff's PIP claims in the case and by the intervening providers. This appeal then followed. In his appeal, plaintiff argues that there are genuine issues of material fact, whether he made false and material misrepresentations in support of his household replacement services claims. The court noted that the dispute here involved the fourth factor in the case of Candor, which is knowing that the statement contained false information. The court concluded that the evidence showed plaintiff knew that the household replacement services statements that he submitted for the months of August through December of 2021 were incorrect. He knew that the person who is providing the services was providing them to his wife, not plaintiff, before the accident, and that the services did not change after the accident. The court also took issue with the fact that plaintiff knew that his provider did not perform certain services but indicated otherwise on the statements. The The court found that no reasonable jury could conclude that plaintiff did not know that he was submitting false information material to his claim for benefits. The court noted that while plaintiff relied on the case of Gary versus Farmers Insurance Exchange, that case was distinguishable. There was evidence in Gary that plaintiff suffered cognitive impairment. In addition, there was no testimony from the service provider in Gary that the services were not actually provided, like with this case. In light of the case of Williamson versus AAA of Michigan, the Court of Appeals rejected plaintiff's argument that misstatements made in the litigation process are not actionable. In that case, the Supreme Court held that the fraudulent acts provision applies to misrepresentations offered during discovery. Ultimately, the Court of Appeals affirmed the trial court's decision in this case. That concludes the July 2025 edition of My PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Please be sure to tune in next month for the latest case law update and trending topics in the PIP world. Take care, everyone.